Just updated your name on there, Janice.
Good morning. For those watching from home, we're just awaiting a quorum before we start the meeting.
Okay, thank you very much, Madam Clerk, and apologies to anybody joining us remotely by Zoom this morning for the delay in getting started. But we'll begin this council meeting by acknowledging that the County of Prince Edward is on traditional land that has been inhabited by Indigenous peoples from the beginning. We thank all the generations of people who have taken care of this land for thousands of years, and we recognize and deeply appreciate their historic connection to the land. Today, the County of Prince Edward is still home to many First Nations and Métis people, and we're grateful to have an opportunity to meet here at work and continue stewardship of the land. This special council meeting is being held at Shire Hall, and the purpose of the meeting is to educate and train members of council with the newly appointed Integrity Commissioner. There won't be any motions coming out of this, so we'll go through the session accordingly. Can I have I guess we'll go with the confirmation of the agenda at this point. Councillor Roberts, seconded by Councillor St. Jean.
Thank you. This is a Robert St. Jean motion that the agenda for the special council meeting of May 6, 2025 be confirmed.
Madam Clerk.
Your Worship, given that we've got a number of councillors absent, it might be a good idea to do the presentation portion of this meeting in public so that it is on Zoom. It's also on YouTube. And then following that, perhaps we could move into closed session for more detailed discussion.
Okay. Is everybody okay with that? Okay.
So we would have an amending motion to
yeah, if we can have
include the presentation in open session, please.
Okay. Councillor Roberts.
This is a Robert St. Jean amending motion that the presentation portion of today's agenda be in open.
Okay, thank
you. Welcome, David.
Those in favor? And that carries. Okay, so with disclosure of pecuniary interest, anything from anybody? No. Okay, so we are now moving into with the presentation. Welcome, Mr. Bogosian. Thank you very much. We've had the opportunity of the slide deck has been forwarded to us as part of the agenda package. It is thorough, it's comprehensive. I speak that when I say that we're looking forward to hearing the presentation as you walk us through this. So I will give you the floor.
Thank you very much, Mayor and members of Council. Good morning. It's my honor to be appearing before you for the first time as your new or fairly new Integrity Commissioner. I'm looking forward to working with all of you as well as members of the county public in enforcing the code of conduct, educating members of council, and dispensing advice as required about the code of conduct or municipal conflict of interest issues. Today we are going to do training on the code of conduct and conflict of interest, both of which are within my jurisdiction to enforce and also provide advice about. Is working, it's just my incompetence. So what this slide deck that I'm going to take you through covers is the role of council, the role of the mayor, the role of councillors, council meetings in particular, the open meeting principle, and the limited exceptions where you can have closed meetings. We're going to deal with the code of conduct. We'll take you through the main tenets, and we'll review the provisions of your code. This presentation covers your exact code. It's not some generic thing. It's the exact code that you're subject to. We'll then deal with conflict of interest issues and the very difficult piece of legislation that the Municipal Conflict of Interest Act is. I'm going to skip the first few slides, which are very general discussions of the role of council, the role of mayor, the role of council. You have my PowerPoint, a hard copy of it, which I invite you to review. Where I want to start is a slide about what councillors should not do. We've included this slide because in my experience of about 4 years now being integrity commissioner, I now have 15 municipalities for which I'm integrity commissioner. These tend to be recurring, the most common recurring issues, purporting to speak on behalf of council or the municipality without specific authorization or direction from council to do so. And a corollary of this that comes up a lot is criticizing decisions of council. You can voice your disagreement and respectfully indicate the reasons why, but you can't disparage other members of council who didn't share your view on a particular issue. And the other thing that commonly comes up is attempting to lobby, influence, or direct municipal staff regarding specific matters other than by means of voting at a council meeting. It is not proper to be attempting to influence staff's opinions on issues. Your voice is to be heard at the council table, not behind the scenes attempting to influence council to do reports that follow your particular views of things. This is just basically about the general nature of council meetings. The only reason I want to talk about this slide is the second item. A lot of councillors, members don't know that if they cannot be at a meeting, they can actually designate another councillor as their proxy to vote on their behalf on an issue. That is allowed. I'll have to get back to you on exactly when that's been in effect, but it is something that is allowed to happen. I beg your pardon? Well, the quorum, the person has to be present, so that's not going to apply if it's not going to affect quorum or the counting of quorum. It simply allows a councillor who cannot be present to vote through another member. I think the way it was set up was that I would do the presentation in public and that we would reserve questions until the in-camera portion. However, I'm fine with questions as they go along. If people are comfortable asking questions, I'm happy to answer any questions in public.
Yes, yeah, well, and thank you, Mr. Mayor, and that's, again, when I read it in here, I was a little surprised. I think we all have the same look on our faces. And I think it's important for the public to know that since we are making this public, this part of the presentation, but how does that work? Do you have to have written notice for a proxy?
Well, I can do a little memo to all members of council on this issue, but yeah, it should be a written email or handwritten direction so that there's no misunderstanding as to what was authorized.
Yeah, okay, all right, no, that's helpful, thank you.
Dave?
Vote twice then. You can vote your own vote and the proxy vote.
Well, I wouldn't call that voting twice. You're voting on behalf of another member, so it's their vote that you're casting, not your own twice, but yes.
Okay, that's the answer.
Bill?
Thank you, Mr. Mayor. So David, quorum here, let's say is 8. So there's 7 people show up on that, and one of the absentees from that meeting says, Sam, you can vote my proxy vote. Does that then move that 7 to 8 and we have quorum?
No, I think I answered that earlier, that would not affect the counting of quorum. It simply is a vote on a discrete issue, or perhaps issues plural that's on the agenda, but not, that counselor is not present, so cannot be counted toward quorum.
Kate?
So closed meetings, as I've indicated, are...
We've got one more
Just,
question.
sorry, no, it's okay. Further to that, that's a provision in the Municipal Act.
Yes.
So, but we don't have, it's a permission, but do we have to adopt it? Can our,
It's there.
it's a permission that the municipality is allowed to do that? Does the municipality have to do that?
It is something that's permitted and I don't believe can be overridden because it's a higher law than a local bylaw or resolution, so yes.
Okay.
Okay, just for clarification, if someone asks another member of council to cast a vote on their behalf, how is that formalized? I may have missed what you
It
explained.
should be in writing
To the
by
clerk?
email. Well, it might help to have, it's not required to be to the clerk, but it should be in writing so that it's clear what the ambit or parameter of the proxy is.
Okay, so,
And obviously it's limited to that issue. If there's a, amendment to the bylaw, for example, then that might invalidate the proxy. It just depends on how the proxy's worded.
right, okay. Thanks.
Yes.
Two proxies.
I don't see why not. I don't think there's any specific provision dealing with that, but there's no limitation on how many proxies can be given to a particular councillor.
So, follow-up question to that. On the two proxy thing, if, for example, one perceives they might have a conflict and they allow another council to vote on a proxy, how does that work?
Well, if you have a conflict, you're not allowed to participate in the proceedings or vote, so that would nullify the proxy as well.
That's what I thought. I just clarified.
Yeah. Okay, one last question.
Not a question, just section 243.1, sections 1 and 2 of the Municipal Act. Guess I didn't read that section a while ago.
Okay,
I'll do a memo. It won't take long, just something quick to
yeah,
address this
okay, that's
issue.
great. Carry on, David.
So one of the most important principles that came out of the revisions to the Municipal Act that brought in integrity commissioners and other safeguards of openness and accountability was to reinforce the open meeting principle. That is, that meetings are de facto to be held publicly. A lot of people don't realize that just doesn't mean a formal meeting like this. A meeting can take the form of an email exchange amongst a quorum of councillors, and if there's a quorum of councillors involved in a email exchange that materially advances municipal business, then that constitutes a meeting and you're engaging in an improper closed meeting. And that's come up for me in other municipalities, and that's something to be guarded against. I think copying the clerk, for example, on email exchanges so that somebody can be aware of what's going on, that can maybe warn members, would be a good idea if there is such email exchanges that could relate to council business. So if you do have an issue that can properly go into a closed meeting, there has to be a formal resolution to go in camera, where the general nature of the subject matter to be discussed is stated in the public open record. And you can go in a closed meeting if the meeting may be closed to the public. A vote can be held in a closed meeting if the meeting is properly closed to the public and the vote is for a procedural matter or giving directions or instructions to municipal staff. If there's a substantive issue to be voted on that arises out of a closed meeting issue, that is to be done in public. So you come back out of the closed meeting and are required to deal with that in a public session. Closed meeting investigations, I'm not sure if there's been any of those in this term of council, but any person, any member of the public can request an investigation to determine whether council complied with the closed meeting provision. Members of council can, of course, be someone to request that investigation. Your closed meeting investigator would then determine if the meeting was improperly held in closed session, and a public report will be generated if a finding is made that it was improperly closed, at which time that report comes to council. It needs to be made public, and council has to advise the public how they intend to address the closed meeting investigation report. Typically that involves indicating why this won't happen again. I can't stress the importance of the open meeting principle. It's subject to certain limited, mandatory, and discretionary exceptions. Open meetings are important to increase public confidence in local government and prevent secrecy in municipal decision-making. So the most common exceptions to the open meeting rule is security of property, personal matters about an identifiable individual, typically a staff person, proposed or pending acquisitions or dispositions of real property, labor relations or employee negotiations, litigation and potential litigation, advice that's subject to solicitor-client privilege, and wherever another statute permits council to hold a closed meeting to discuss the issue addressed in that legislation. And there's some more esoteric exceptions to the open meeting rule on slides 14 and 15. So now we're at the Code of Conduct. Every municipality in Ontario has to introduce a Code of Conduct, and that Code of Conduct has to have 4 mandatory sections. One dealing with gifts, benefits, and hospitality, another regarding respectful conduct, another involving dealing with confidential information, and the final mandatory section being the use of property. And the purpose of the Code of Conduct is to ensure public trust and confidence in the municipality's decision-making and operations. So Section 4 of the county's Code of Conduct deals with confidential information. We're going in order that they appear in your code, not the order that I dealt with them on the previous slide. Confidential information includes information in the possession of or received in confidence by the county that is either prohibited from disclosing or required to refuse to disclose under MFIPA or any other legislation. Your code also stipulates that members shall not use confidential information for the private interest of themselves or any other person. Members shall not disclose any confidential information acquired by virtue of their office unless authorized by council or required by law. And nothing disclosed in a closed meeting is to be disseminated publicly unless specifically authorized. Section 5 of your code deals with conduct at council and committee meetings. Members are required to conduct themselves with decorum and follow the procedural bylaw of the code and other applicable law. Decorum is not a defined term. I've defined it in adopted definitions in various reports that I've issued for other municipalities. What I have said is that, particularly where there's debates on controversial political issues, in some municipalities that includes encampments, housing issues, where opinions can be strongly held. There can be unfortunate missteps in terms of how positions are articulated or the positions of other parties are described. So there's a bit of leeway when we're dealing with these kind of political issues where we know that the heat can rise in terms of the debate. Accidentally flipped it around. Section 6 is conduct respecting others. All members have a duty to treat others, including the public, other members and staff, without abuse, bullying, or intimidation, and ensure that their work environment is free from discrimination and harassment. The Ontario Human Rights Code and the county's harassment and violence policy are adopted by reference into the code. If it's a true human rights code matter, I would decline jurisdiction and refer the individual to the Ontario Human Rights Commission, because the mandate of the Integrity Commissioner is to, if there's a specialized body that already deals with the matter, I am to defer to that body rather than addressing it myself. Improper use of influence. No member shall use their office position to influence or attempt to influence the decision of any other person for the private advantage of themselves or others. They're not to use their position for any other purpose other than their official duties. And you shall not interfere with persons performing duties under the Provincial Offences Act or similar legislation. I gather this deals with bylaw enforcement and councillors attempting to get involved in determining whether charges should be laid or withdrawn. And that really applies to other legislation as well. You shouldn't be getting yourself involved in property standards matters or bylaw building inspection matters. Or anything to do with enforcement of the building code. That just really goes back to the main point that I made, more general point I made earlier, which is you should let staff do their job without interference. Section 8, conduct respecting staff. Members shall be respectful of the role of staff to provide politically neutral advice without member influence. Understand that staff serve the county as a whole and under the direction of the CAO. Members should not direct staff to engage in political activities. They should not falsely or maliciously injure or impugn the professional or ethical reputation of staff, and should not use their position to intimidate, threaten, improperly influence or coerce staff or interfere with their duties. I actually had a case arising out of the recent provincial election where a councillor who is a big supporter of a provincial candidate conscripted his staff into assisting with that MPP candidate's campaign, and it was complained about, and that led to a finding of a violation. Section 9 covers use of municipal property. Municipal property is defined as property, equipment, services, staff, and supplies. No member shall use municipal property for personal purposes or profit or for any other purpose than the discharge of their duties as a member. No member shall obtain financial gain from the use or sale of county intellectual property, computer programs, technical innovations, patent, trademarks, or copyright held by the county. Obviously, I don't know if you might have municipally issued cell phones. No, okay, then I won't even go there. Yes.
We have a choice to be compensated for the use of our personal ones. How does that affect anything with regards to that issue?
I actually dismissed a complaint from another municipality on this exact thing, where your personal cell phone is your business. It's not regarded as county property, and it's not something that I, for example, as an integrity commissioner, can automatically access, as I could, for example, your email accounts or your cell phone account if it was a county issued cell phone. Yep.
So regarding equipment use, this is perhaps a little too picky an example that's not going to happen very often, but I've had to trade devices when mine has failed because the camera hasn't worked for Zoom, etc. I've traded devices with my daughter. She's used my work device so that I could use her personal computer to join meetings. So, and just because of timing, she's needed a device quickly. And there's a municipal purpose involved, but it's personal use of a municipal device. So how do I manage that if it ever happens again?
So you have county issued laptops?
We do.
Okay. So anything on that laptop is going to be regarded as public property, and that means, for example, if I'm doing an investigation, I have a right to automatically access that, as opposed to, for example, if it's a personal computer or cell phone, if I really thought I needed to get information, I'd have to go to court and actually get a court order to do.
Okay.
Big difference. However,
So it's not, I'm just worried if it's improper use. I don't think she cares if you can see her homework.
yeah, I was going to get to that. So ancillary uses, I had a complaint where, at a municipality where there's a lot of strong political divisions, one councillor complaining that another councillor was using their office phone, to help organize a charity event that had nothing to do with the municipality, and complaining that they were using municipal property for an improper purpose. And I said, well, it's an ancillary use. In other words, if it's a minor or ancillary use described, I certainly wouldn't regard that as a violation.
Thank you.
Section 10 expenses. Members must adhere to all policies with respect to any expense reimbursement. Falsifying receipts or signatures is a breach of the code. Section 11 covers gifts, benefits, and hospitality. Members can receive gifts, benefits, or hospitalities as part of social protocol or community events linked to a member's duties. For example, if you attend a function like a fundraiser or something, and someone gives you a token gift like a pen or something as show gratitude for your attendance and support, that's perfectly fine. Accepting a gift or benefit beyond nominal value can imply favoritism, bias, or influence. Members must represent the public and the county with impartiality and objectivity. These are statements right out of your code of conduct. No member shall accept a gift or benefit. And gifts or benefits are not defined in your code, but they're generally defined elsewhere as money, sports tickets, concert tickets. I had an issue come up where a person received the use of a cottage for a week. That's a benefit. If someone's lending you their cottage for a week, you need to regard that as something falling under Section 11 of the code. No member shall accept a gift or benefit that a reasonable member of the public would interpret as gratitude for influence, given to induce influence, going beyond the necessary and appropriate public functions. And I think what that really means, going beyond the necessary and appropriate, is like a gift that's out of proportion to what a reasonable person would expect would be appropriate given the circumstance. For example, instead of a pen, you were given a $500 gift certificate for appearing somewhere. I think that should raise red flags with you. Yep.
What about campaign donations?
That's expressly exempted. Well, it's exempted under the Municipal Conflict of Interest Act as it not being a pecuniary benefit, and it wouldn't fall under gifts, benefits, or hospitalities either. Yeah, the Municipal Elections Act covers that as well, and so as long as it's done properly reported, then you have no problem with political contribution. A gift or benefit provided with the member's knowledge to a member's spouse, child, or parent is deemed to be a gift to that member. Section 12 covers election-related activity. Using municipal property and staff time for election-related activity is improper. Every member shall follow the Municipal Elections Act and the county's election policies and procedures, not use municipal property to promote or oppose a candidate. That goes to my earlier example of a councillor attempting to assist a provincial candidate in an election. That it's certainly not proper to use the resources of the municipality for that purpose. And your code specifically says this entire section applies to elections for municipal, provincial, or federal office. There's Section 13 prohibits reprisals or obstruction of my investigations. Members are to respect the code and all investigations commenced in relation to it, cooperate with the Integrity Commissioner, not obstruct the Integrity Commissioner in furthering the objects of the code, such as destroying evidence, deleting emails, and not threaten a reprisal against a complainant or any other person providing relevant information to the Integrity Commissioner. So my role is essentially threefold. In Section 223.3 of the Act, there are 7 things set out, but they're very repetitive. Essentially what I do is I respond to complaints about breaches of the code or the Municipal Conflict of Interest Act, conducting investigations if they pass a certain threshold, one being it being within my jurisdiction and not within the jurisdiction of a more specific body. Advising and also determining that there's sufficient grounds, or what we call reasonable grounds, to proceed with the complaint. Integrity commissioners are not supposed to be, conducting inquisitions that, oh, I have a feeling that this is going on, can you investigate? there has to be specific evidence of a specific breach, at least enough to satisfy me that there's sufficient grounds to take this further and that it's not speculative. I advise you about your obligations under the Code and the Municipal Conflict of Interest Act. I can't stress enough that getting advice in advance is a lot better than trying to explain things after the fact where a breach has occurred. And the third main duty of an integrity commissioner is to provide training and education about the Code, the Municipal Conflict of Interest Act, and the application of any policies falling within the Code, in other words, adopted by reference, governing councillors' behaviors. If there are policies that are not related to ethics or integrity or the Code, I will decline to provide advice to that. That should be taken up with other corporate counsel. So my phone number and email address are published on your website. I encourage you to call. My office number and extension is forwarded to my cell phone at all times, so I'm pretty much available all the time. We much prefer to get requests for advice in writing for the sake of certainty, so we know exactly what advice is being sought. There are times we recognize that, at the last minute you realize, oh, maybe I have a conflict on a particular issue on an agenda. The meeting's in a couple of hours, so you don't have time to write to me and worry that you won't get my response. So in those circumstances, a call to get a verbal opinion is fine. I will always put my advice in writing, what I understood your advice, the advice sought was, and what my advice is, so there's no misunderstanding. The better approach is to put the request in writing, and my advice will always be in writing back. If you purport to share my advice publicly, often defending how come you're voting on this issue, and someone will say, oh, the integrity commissioner said it's okay. If that wasn't in fact my advice, or certain qualifications on that advice were not disclosed, I have the right to release my entire advice to ensure the record is straight. So in terms of the formal complaint process that's dealt with in Section 15 of the Code, any individual, including a member of council, can file a complaint. It has to be in writing, and it's sent directly to me at the email address on the website. The complaint must be signed and dated. Must be a natural person or an individual, not a group, organization, or corporation. If there's any doubt, I will verify that, in fact, the person purporting to make the complaint is who they say they are, if there's doubt about that. Every complaint should be an explanation with specific reference to the Code as to why the issue is a contravention, evidence in support of the allegation, and names of any witnesses to the contravention. With respect to the specific reference to the Code, a lot of complainants are lay people who have a sense that something's not right about something and may not be able to refer to a specific section of the Code, so there's some latitude in working with the complainant if they appear to have a legitimate complaint to assist them to frame it in terms of what section of the Code is being breached. Complaints have to be submitted within 60 days after the alleged violation. It's not stipulated, as in a lot of acts, a lot of codes that I deal with, it's not specifically stipulated, but there is a body of law amongst integrity commissioners. If you're ever interested in integrity commissioner law, there's actually it's on Canly. There's a website called Canly where they have integrity commissioner decisions as a category. Canly's a national database of judicial and quasi-judicial body decisions. But what we do is imported discoverability principle. Even though it's not expressed in your code, we will do that. So if someone couldn't discovered the alleged violation within 60 days, we'll look at it applying a reasonable excuse and lack of prejudice test. Okay, we're turning now to the second main topic of my presentation, which is conflicts of interest. The Municipal Conflict of Interest Act is a very difficult piece of legislation. It's very poorly written and organized. And it's extremely surprisingly broad, shockingly so to some people not familiar with it. Essentially, a conflict of interest is defined as where a council member, either on their own behalf or while acting for, by, with, or through another, has any pecuniary interest, direct or indirect, in any matter and is present at a meeting of the council where the matter is being considered. Certain steps have to be followed. You need to declare your conflict, accuse yourself from any participation in the debate on the issue, and abstain from voting. You do not vote on the issue. If the matter concerns an issue that's being dealt with in a closed session, the member actually has to physically leave the meeting space until that issue has been fully dealt with. Pecuniary interest is not defined, believe it or not, in the statute, but what it's come to be defined, it's been defined in common law, which means determined by judges and integrity commissioners more recently. So here's some things to keep in mind when you're dealing with conflict of interest issues. They cover direct and indirect conflicts. A direct conflict arises when a member stands to gain a direct benefit because of a certain municipal project or matter. That could be a financial gain or a gain in kind as a result of a vote on the matter in favor of the interest of the councillor. Indirect conflict may arise where a member is a senior stakeholder in a private corporation, owns a controlling interest in a public corporation, or is a member of a, quote, body that may have a direct pecuniary interest in the matter. If you were, and we're going to get to some examples, but this idea of body is extremely broad. It's been held, for example, to include membership in a First Nation. So if the First Nation has a dispute or litigation against the municipality, if you are a member of First Nation that's involved in that, you have to recuse yourself because you are a member of a body according to the law. Same as if you're a member of the Chamber of Commerce, for example. If the chamber comes looking for some grant or benefit from the municipality, any member of that Chamber of Chamber of Commerce, thank you, that is a member has to follow the conflict of interest rules about recusing themselves from participation. Yep.
Okay, thank you. My question is, when is it a direct or indirect conflict, or / when is it life experience? So example of let's use, I have young kids. When I got into the job, they were daycare age. I was voting on daycare questions. Even if my kids didn't go to that daycare, they could have. Is that pecuniary or like life experience?
Okay, so we're going to get some exceptions, and one commonly relied on exception is if the member has an interest in common with members of the public generally. So that if you have an interest in common with members of the electorate generally, then you do not have a conflict of interest within the meaning of the Conflict of Interest Act. And it doesn't just have to be, it doesn't have to be in common with every single person in the municipality. If it's parents with children, that's a sufficiently large subset that can be regarded as electors generally. This is very confusing and convoluted legislation, so that's why if there's any question, you should probably err on the side of getting advice from me.
Sorry, just to follow up on maybe a more weird subset. So like dairy farmers. It is a very specific, usually a lobbyist group that has direct ties to government. When would that shift from being but it is in an agricultural town, a direct, like a body of interest? So like, when does it shift from being like a dairy farmer supporting agriculture to a dairy farmer specifically helping legislation that benefits dairy farmers on a whole?
Well, certainly if you said the example was the farming community generally, and for example, to do with a lower, I don't know if you have surcharges for stormwater management, stormwater drainage. I don't know, that's an issue elsewhere. But if it was an issue like a lower tax rate for farmers than what was previously provided for, the farming community generally is a subset of electors generally, so it would fall within that exception. When you're starting to get into a specific subset of that group of farmers, like dairy farmers, I'd have to know more information, like what proportion of farms in Prince Edward County are dairy farms as compared to farms as a whole. I mean, there'd be some questions to ask about to determine if there is there's a reason to believe there's a conflict, or if that exception applies. There is case law that says, for example, in a high-rise condominium building, if a councillor is one resident of that building and they're voting on something to do with that building, it has actually been held by another integrity commissioner that that person had an interest in common with electors generally, being the subset of those living in that large high-rise condominium building. I'm not sure I agree with that, but that's been determined, and probably I'd follow precedent if it came my way. I think Councillor St. John had the hand up first.
I know I've already spoken. I was going to defer to Councillor Roberts, but it's interesting because I know this particular topic's interesting for me because there has been public discussion, in fact, at the podium, with regards to members having associations in the community. Several of us have been, it's been pointed out that we may have a non-pecuniary interest because of a membership in a group that may or may not be benefiting from a decision of council. I'm going to use an example like PFAC, which is aquatics facility here that receives funding. And it gets very gray when you start talking about that because, you could have a membership of 300 and I may be one of them. Not that I am, but just by example, where they, an organization receives a substantial amount of funding. Same can be held with other, I'll say, service clubs and other organizations in the community. Where do you draw the line?
Well, there hasn't been perfect consistency in the law, but there have been cases, I think you want to err on the side of following the worst case cases that have found conflicts as a result of membership of a body. But I would say that if you were a member of this, I don't know if it's a community center, I don't know, aquatic facility.
Yeah, that's just an example,
You are very likely in the boat of having, I need to know more to see if it might fall within that definition of electors generally, if it was open for any member of the community to join, what the parameters are. But it's definitely something that I would call about to, and so I could gather some facts from you and make an informed, give an informed opinion to you as advice.
I'll use my own example where I did declare with regards to a service organization that had an arrangement with the municipality, a tenancy document. At the time, I was a signing officer. To me, that was very clear. I have power and authority within that organization. So to me, it was very clear that I did have an indirect pecuniary interest. But just as a regular member, as I am now, I wonder, personally, I don't believe I do now, because I am not in care and control of that organization.
Unfortunately, the courts and other integrity commissioners have decided otherwise than what you think, because merely being a member, like, you don't have to be on the council of First Nations council to be classified a member. If you're just a member, then you're covered, and you have to declare a conflict. Same with the Chamber of Commerce example I gave earlier. If you don't have to be on the executive of that organization to still be regarded as a member who therefore has a pecuniary interest if they come looking for a grant or some other benefit from the municipality.
Okay, well, that's helpful, because I can tell you right now, just about everybody on council has some form of membership and affiliation with a community group. So if they, if an issue comes forward for a decision of council, then they should be stepping aside, declaring that non-pecuniary conflict of interest.
Yeah, I think the full scope of the act is very probably are a lot of conflicts that are going undeclared, not because anyone's away with anything, just because of lack of understanding of the MCIA, the Municipal Conflict of Interest Act.
Absolutely. Thank you.
Thank you, Mr. Mayor. I'll just run through some family examples. And it seems to me, David, that the way the law or precedent is established is perhaps a little punitive to small communities like ours versus a big city. So if I'm a member of the library and they're looking for renovation funds, or a hospital or hospice board member or advocate involved with hospice or the hospital, or the Rod and Gun Club, coincidentally gets its road redone, or a service club that's seeking money for a Twin City project or our own Ukraine working group. I mean, we're all involved in a lot of stuff. Or spouses, for example, who are on a children's literacy not-for-profit organization here in the county, or in a food insecurity organization which is looking for grant monies. It's indirect, but it flows essentially from municipal coffers. I mean, we're going to get entangled in an awful lot of shit.
Well, I sympathize, and I'm integrity commissioner for municipalities are much smaller than Prince Edward County. I've heard this before. I personally try to inject a degree of latitude to recognize that, but one can't avoid the plain terms of the act. As the last bullet on this slide, for example, says, it extends to any parent, spouse, or child of the member who has any of those associations. So it is extremely broad. I didn't write this legislation, and if given the opportunity, I would rewrite it because it is absolutely horrible. It's one of these things that, like, whoever heard of an act where the exceptions come before the rule? Like, there's many problems, and it's just sort of been added to ad hoc over the years to plug holes as they are seen to come up. So it's just this really unwieldy thing that's been built upon without anyone maybe taking a big picture look at, how far does this go, and is it really appropriate for all places? I mean, a lot of these amendments came out around the same time as the Integrity Commissioner provisions, the transparency, openness and accountability provisions of the code came out of an inquiry that was dealt with the City of Toronto. So, I mean, obviously, a lot of the recommendations that came out of Justice Bellamy's report that kind of led to a lot of these changes and toughening up of ethical standards and may not be appropriate for everyone. I would suggest that you lobby your local MPP to have this looked at, because as it stands now, you're absolutely right that it's extremely broad and probably punitive to smaller communities.
Thanks, Dave.
Pardon me. Excuse me, I was sick all weekend. On the mend now. The language in our code of conduct urges us to avoid any appearance of a conflict of interest, and I think the legislation also does. That language is even more broad and difficult to pinpoint. The appearance of a conflict can differ depending on whose eyes are looking. And I'm just wondering how we can adhere to the spirit of that when appearance, and I think the phrasing is both apparent and or real is the phrasing. How do we adhere properly to the spirit of that without without losing some traction on our responsibilities to be here for our constituents and be here for our community?
Well, I'll give you examples. City of Toronto and City of Hamilton's codes of conduct have similarly broad wording. However, they have a distinction built in that's between disqualifying and non-disqualifying interests.
Okay.
The MCIA does not cover a parent. It's hugely broad, but it doesn't cover appearances unless they actually fall within the section. Codes of conduct tend to. What some of these municipalities like Hamilton and Toronto have done is on these non-true pecuniary conflicts where it may be an appearance, fill out a form, a disclosure form that basically says, here's I have this relationship with so-and-so who's the proponent of this particular initiative that they want the municipality to pass. Here's why I think that a reasonable member of the electorate would not believe that I could not objectively deal with this. And those are actually provided in their codes to the integrity commissioner to vet in advance to see if
Right.
the integrity commissioner agrees or not. And if they do, then you can say, I am declaring what I consider to be a non-disqualifying conflict, and I pass it by the integrity commissioner and he agrees. So that there's those provisions in those codes. I administer the City of Hamilton Code of Conduct as their integrity commissioner, so you may want to consider whether you want to adopt something like that. And that disclosure form then becomes a matter of public record.
And that's something that we could informally already do, I presume, with a submission. It's sort of covered off with a submission to your office to say, do I have a conflict in this matter? Is it close enough?
Well, you don't have the kind of enabling wording that would permit that process to happen right now, but it's something that could be pretty quickly. I don't want to say quickly, but could be without a lot of effort drafted.
We could include it in our.
Thank you, that's interesting.
That could be included, yep. And
Yeah,
there are precedents in a few other places.
I was going to ask you more broadly what you thought was missing from our document, but we can get to that after, but I agree we could add that.
That's
language.
one example.
Yeah.
I notice your code doesn't have disclosure statement. I don't believe, unless I've overlooked it, but gifts and benefits disclosure statements, if they're over a certain dollar value, is a common thing in codes of conduct, and those being submitted to the integrity commissioner to determine if the gift was appropriate or whether it needs to be returned. That's another example of something that's a lot of
Could include,
codes have that this one doesn't.
Okay. Dave?
Yeah, I have a kind of a little different question here in a way. I've been at this council business off and on for longer than I like to admit. But when the first councils I sat on here were mainly made up of landowners in the agricultural side, business people, and professional people, dentists, things like that. Over the years, partially thanks to this act and length of term, it's very difficult to get people that are in business or elsewhere to run, because the first thing they say is, why would I put myself through that? Especially, as Bill alluded to, in a smaller community, which this is. And so at the end of the day, we seem to be squeezing that sector out of our council because they will not, do not want to run and put themselves through the hoops. And I can't say as I blame them. I've been there, done that, had to work through it. And when they say that, I have to say, you're right. So I don't know how you address that, and there's not really a question coming out of that except, would you, if you were in business, run? That's my question.
If I was a real estate developer, certainly not. I mean, there's just too much scope for conflict and too much scope for public criticism and whispering about, oh, you're getting sweet deals or you're getting all this. So I didn't draft this legislation. I think it's a mess. Like I said, bring it up at AMO. Get this on their agenda. They have a lot of clout with the government, and that may be something to talk about. Your local MPP. I can only go so far. I can try to temper the most harshest impact of this legislation, but you know, this is provincial legislation. There's a lot of and you know, you can't really diverge too far from precedent interpreting it. So you know, there can't be a set of special rules for any particular place. It's provincial legislation, and I sympathize that it probably is an impediment that you may want on council for being on council. That's a legislative issue, unfortunately, not an interpretation issue. There's lots of law interpreting this, the MCIA. This is not uncharted ground, and it both in its plain wording and as it's been applied is quite harsh in terms of the scope of things that are conflict.
Thank you.
Thank you, David. So how old is this policy, and is there any talk of it being updated? It seems really archaic.
The MCIA, the municipal conflict. Well, it's old. It's very old, but what's happened is it's sort of been through just a patchwork of amendments, has been made increasingly more draconian. It's like, oh, this happened, so we need to plug this hole. You know, let's slap in some extra language here, and before you know it, you know, you've got this really extended definition. So not only is it your or a public corporation or a member of a body or being an employee of a corporation or an employer that has an interest, a pecuniary interest in a matter, but now it's your spouse as well. That's what the legislation says, or your child if you have adult children or parents. So it is extremely broad, and I'm not aware of any active effort to amend this legislation or change it. There is talk, as you probably all heard, before the last provincial election of amending the Municipal Act to put a little bit more teeth into the code of conduct by, for example, allowing recommendations to remove a member from council. There's a lot of hoops that have to be jumped through before that could actually happen, which I think may never happen. There was also talk about having a uniform provincial-wide code, which never got off the ground either. But on the Municipal Conflict of Interest Act front, I'm not aware of any active discussions by anybody. But again, if you get it on AMO's agenda, it might, might spur some action. I guess I should be deferring to the mayor. I should.
Feels like it's rather relaxed today. So, okay, I think you may have just answered my question, but I'll ask it anyways. With regards to, I'm assuming there's not an association, but at least a loose association of integrity commissioners for Ontario.
There has been, and they're trying to resurrect it. It's been kind of dormant for the last few years. Okay. But yes, there is talk of even getting a meeting together in the fall.
So if there were, if a body were to put together a resolution to be circulated amongst, let's say, AMO, Roma, requesting that the province make these changes, because I think we're all becoming aware that at any given time, every one of us has been in conflict unknowingly, and the confusion that can arise from all of that. So I don't know, just a suggestion to you, maybe you can fire up an IC's association and get on the province, because with coming changes to the municipal act that you just mentioned, I think your voices are going to be necessary to be very loud and clear, because you're the ones that have to apply all of these new regulations and legislation. So I'm hoping that maybe there can be some advocacy from those that have to actually apply these rules and regulations, and when they're very as you say, broad patchwork. You know, there's a lot of finger in the dike going on here legislatively.
No, I'd be happy to lobby that group to throw their support behind any initiative to rewrite this legislation and make it more comprehensible and perhaps more focused and less broad.
Certainly applicable to smaller rural communities that have, these tentacles.
There's so many associations in a smaller community,
Yeah.
and I see it in even smaller communities. It just gets worse the smaller it is. And yes, I think this legislation was probably drafted for large urban centers where you might not have nearly as much potential for conflict.
Anyway, go on, David.
Yeah, so
Good discussion.
I think the fourth bullet's the only thing I haven't really talked to. It again, if you're in a partnership or you're employed by someone that has a direct pecuniary interest, and that's deemed to be your interest as well, and then it gets even more extreme because that applies to these similar relationships of your parent, spouse, or child with an employer, a partnership, a corporation, or membership in a body. Conflict of interest examples. So pecuniary interest has been defined at common law because, again, it's not defined in legislation as a financial or economic interest or money in some shape or form. The key question is, does the matter to be voted upon have the potential to affect my pecuniary interests? Now, it can't be a speculative interest. Like I had a member of council just recently at one of these training sessions ask, well, I'm a real estate agent. We've just approved 40,000 new housing starts, and I'm bound to, business is bound to pick up for real estate agents generally, and I'm hoping for myself. Does that mean I have a pecuniary interest in voting for this? And I said no, because that's pretty remote, speculative. I'm certainly not gonna say that that's gonna disqualify you just because of this chance of you down the road at some point receiving some benefit. Yeah.
What about where some of these bodies are partially populated by appointments from council? For example, council appoints council members to the library, to business improvement associations, which then also receive municipal grants, directly or indirectly. How does that work?
Okay, so there is an exception for being a member of a local board or committee. We'll get to it, but there is a specific exemption for that. So the first example, these are from real cases that were decided by the courts. Influencing or participating in decisions of council to locate a municipal development near their property is a direct conflict. So the actual facts, or specific facts, were a councillor owned a sporting goods store in a strip mall across the road from a municipal land that was being considered as one of a number of options for a new community center that would have a couple of ice rinks. This sporting goods store sold a lot of hockey equipment. It was a big part of the business. And he was actively lobbying to get this community center built across the road from the strip plaza. The courts found that because he stood to benefit from having hockey players, coming to the facility across the road, that he had a conflict. There's a conflict of interest found there. There was no declaration, so there was a finding of breach of the act. A member of Chamber of Commerce voting on a resolution to give a grant to the chamber is an indirect conflict. We've already mentioned this. That's an actual court case. And again, because that's a body and you're a member of the body, you're, you know, on the wording of the legislation, that's a conflict. Here's a couple of examples of what is not a conflict. A councilor's family member attends council to provide information and or municipal staff are directed to report on the legal implications of a decision. There's no pecuniary interest. And then here's that exception we talked about, interest in common with electors generally. I think I've already alluded to this example. Participating in a motion concerning the hookup of water service for large condominium residents while living in such a condo is not a conflict because the issue is one that is in common with electors generally. An interest in common with electors generally means a pecuniary interest in common with electors in a particular jurisdiction. You know, I had a counselor in a small vacation destination municipality say, well, I don't want to give too many specific facts to identify anything, but it was like everyone who held, the municipality gave out permits, let's just say, for something, to access the dump. Trying to change the facts on the fly just so I don't make it too obvious, but it was like, well, and then the vote was to increase the cost of the permit, limit the hours that the dump was opened, close the dump, and the councillor said, well, isn't this a matter of having an interest in common with electors generally? And in that case, and it wasn't a dump because it was a much more discreet type of permit, and essentially the class of electors was the ones that had the permits. And I said, well, you can't really define, you know, the very people that are subject to this. It's hard to explain, but I just didn't think it was a sufficiently broad class of persons that it could be an interest in common with electors generally. Oh, yes.
So, and I know that this is maybe even crossing some lines here with trying to understand a complicated way you're going to have to make some decisions. But with example number one, you say that where there's no pecuniary interest, family member attends council, provide information. But when development matters at a planning committee where, let's say, an environmental group is opposing certain developments and a member of council is on or a senior leadership role in that particular environmental group, is that member, in your opinion, now conflicted?
So the environmental group is opposing the development.
Yeah, I'm just, again, an example.
So in a nutshell, I don't see a pecuniary interest there. In other words, the environmental group isn't standing to benefit. There's no pecuniary interest.
Okay.
I mean, it's advancing a position, but it isn't standing to gain financially. So there's no pecuniary interest there.
Thank you for that clarity.
So when someone sends you an email, a member of the public, and they're complaining about something and they're not happy with your decision, can they appeal that to some other board or whatever?
They can do two things. One, they can complain to the Office of the Ombudsman over Integrity Commissioners. I disagree. I don't think they do. I think we're a quasi-judicial decision maker and they don't have power over us. And the other way is to seek judicial where you can ask a judge to decision for reasonableness, not correctness, but reasonableness. Is it within a range of reasonable outcomes or plausible outcomes of the facts applied, the code applied to the facts.
Can I just ask one other question?
And if it's, right, on the conflict of interest side, so the way it works is an elector or member, it could be a member of council, any member of the public can make a complaint. It has to be within 6 weeks of when become aware of the potential. I then review it to this, perhaps do an investigation to see if there's sufficient grounds to refer it to a judge. And if I decide to refer it to a judge, I then am obligated under the Municipal Act to prosecute. Yeah. Conflict of interest. In that case, there's a, obviously my decision is effectively being appealed to a judge, and then there's a right of appeal from that judge's decision if someone's not happy with it. Yep.
Can you go back to what you were saying, whether you question whether the Ombuds Office does have jurisdiction when the Ombuds Office believes they do have jurisdiction? Is that because it's not represented in legislation, or is there another reason?
There are exceptions to the Ombudsman's jurisdiction that cover what I consider to be quasi-judicial decision makers. Like if someone doesn't like a decision of the Committee of Adjustments, then that's not something the Ombudsman quasi-judicial making body, and I regard integrity commissioners as. The Ombudsman Office has taken jurisdiction or has claimed to have jurisdiction. I had one thing referred to the Ombudsman's Office. They rejected the complaint about me, but part of my response is you don't have jurisdiction over me, and they ignored that. They just dealt with the merits and said thought what I decided was reasonable. Okay, exceptions, using public utility services, receiving benefits on terms common to others, we've already dealt with that, purchase owing debentures of the municipality, making a returnable deposit to the municipality, having any interest in property affected by statutes related to local improvements, having an interest in farmland with some statutory tax exemptions, being eligible for election or appointment where council may fill such vacancy, being a senior officer of a corporation incorporated to carry on municipal business, receiving remuneration as part of a volunteer fire brigade, having a pecuniary interest in common with electors generally, and having an interest so remote or insignificant it is not likely to be of influence. So where I have scope of potentially tailoring this legislation to, the particular circumstances of a municipality, such as size, those last two, may receive a more expansive definition than otherwise would. These are very brief, and again, the exceptions are almost as convoluted as the rules, but there is one that covers if it's a municipally appointed position, you're not thereby disqualified. And then if you do have a conflict or think you might, you have to disclose the interest at the meeting where the matter is being considered. Following that, you can't discuss, attempt to influence anyone on the vote or actually vote on the matter. If the meeting's closed, you have to leave while the matter is being considered. And after disclosure, the member files a written statement of interest with the clerk. Disclosures are recorded in meeting minutes and statements available to the public through a local registry. So that for example, the Hamilton and Toronto examples, they have the disclosure statement for both actual declaration of a disqualifying conflict, and also for the non-disqualifying where there may be an appearance, but you say, here's why, notwithstanding the appearance, I see has agreed with me. So there's a provision: if many council members are prevented from participating, quorum will be maintained as long as there are more than 2 members who can vote. If there are fewer than 2 members, a judge may authorize council to discuss and vote on matters that actually happened not that long ago in Vaughan, where a litigant, I think it was a real estate developer, was very unhappy, sued the municipality and every councillor, thereby preventing them from instructing council because every single one of them was conflicted because they were all being personally sued. The judge said, you can go ahead and vote on it. So I've already talked about this. If I get a complaint about breach of the MCIA, I can be asked to conduct an inquiry. The application should be made no later than 6 weeks after the alleged contravention. And there's actually 6 years to complain. However, the application has to be supported by a statutory declaration. In other words, a sworn statement. I then investigate. And I have to deliver a report. It gives me 6 months, but every investigation I endeavor to complete at the most in 60 days, at the worst. And usually sooner than that, because I don't want things to fester and have something that was a controversy months earlier suddenly get, resurrected in the public eye, in the media, months later. So I try to get it done very quickly. And this is just the procedure. I don't know if you need, we've sort of touched on all this anyway, and I'm conscious of the time. So basically, if I find that it's frivolous, I can decline jurisdiction because it's not within my mandate, or it's within the mandate of a more specific body, like the Ontario Human Rights Commission, perhaps the Information and Privacy Commissioner. If it's a police matter, the legislation says I'm to refer to the police and not do anything until the police investigation and any charges have run their course. I can refuse an investigation also if I think it's frivolous, vexatious, or not made in good faith. There are not sufficient grounds set out to support an investigation. And in that case, there's no public report if it's dismissed, simply a letter to the complainant and the person that's been complained about. If it does go further, there's an exchange. I advise the member I either provide the verbatim complaint or a synopsis or a summary of it to the member. That's supposed to be responded to within 10 days. Then I give the response to the complainant, their response within another 10 days. And I'm also able to pretty much interview or even summons and examine under oath anyone I think that might have information of use to the investigation. I can also ask the municipality for any documents that may exist, and I will often ask the member complained about for additional information and perhaps documentation. And then if I do find a breach, I do report to council in a report that's supposed to be made public. And your code says that I am required, and I really dislike these provisions, that if I decide I'm going to recommend a sanction, I have to give the member a chance to respond to that, which to me just adds a bunch of time to it. I'm quite frankly very unlikely to change my recommendation because I've already had probably a full discourse with that member about the circumstances. And the other thing is that on the penalty, I mean, you can't, council ultimately decides if the penalty is imposed or not. And I think the appropriate forum for a councillor or a member to object to the recommended sanction is at council meeting before the council that's going to decide the imposition, not arguing with me about whether my recommendation is reasonable. So I don't like provisions like that, and I would take that out if I had the chance. Other places have it too, and I find it's just a big waste of time. It's just a regurgitation of everything they've already said. Usually it's already been exhausted, the entire issue. There's a blackout period between nomination day and election day where I can't continue or accept any new complaints. I can't continue investigations or accept any new complaints. Penalties, reprimand, suspension of remuneration for up to 90 days, a request to repay, reimburse, or return property, removal from committee or local board or as chair of a committee or local board. It's funny, but if it's a local board person, I can remove them from office completely, but not if they're a member of council at this time. And this is just almost for interest, but these are grounds, and you can read it on your own, that you could be removed from office. And that completes my presentation. Sorry it's been a bit longer, but I do appreciate the interaction, the feedback. It's been great.
Another question here.
Oh, okay.
Not that this happens in Prince Edward County, but what if you get like inundated with complaints from the same person?
Then I start looking at that frivolous vexatious. And I've rejected complaints, and there's one municipality in particular where there's this rabid group of objectors, or there's other more colorful terms for this group. But yeah, so I'm conscious of that, and I'm conscious of people that are just trying to stir the pot and not really advance the underlying tenets of openness, accountability, and integrity that the code is supposed to be promoting.
Thank you.
Thank you, Mr. Mayor. David, you mentioned briefly during your presentation that the province is now going to look again, after being asked 3 years ago to look at a standardized code of conduct, and AMO reported on this yesterday in a message. Do you have any inside knowledge as to what they're looking at, or
No,
how that might relate to our code of conduct?
I don't, and I think that legislation died and will have to be resurrected. They were going to do it, and I disagree with the process. They were going to have a regulation saying the province or lieutenant governor and council can promulgate a standardized code. I would like to see that code appended to the legislation so everyone can see it up front, instead of something that's just going to be, worked up behind the scenes and sprung on everyone without consultation. I know they were consulting with the Ombudsman Ontario and the Provincial Integrity Commissioner. I'm not aware of any other consultations, such as with people acting like myself as municipal integrity commissioners.
They do have this annoying habit now of putting all the power on the lieutenant governor and council rather than elected representatives. Just an editorial comment.
Okay, I would just say, I'd like to say thank you very much for this presentation, because it's very often been the most common questions around here as to the scope and what is involved in this, and at what point you should possibly be consulted. And I would like to make the suggestion, thanks again to the clerk, that a copy of this goes in every mailbox for every counselor, because it really, what you presented outlines very well what we might need, and put it on file. I know you have it on there. I realize that, but nonetheless, quite a few counselors, or some counselors, may not. And it's very concise, to the point, and again, thank you.
You're welcome. Thank you.
Sorry. One of the earlier slides, David, talked about, or you talked about, council, the position of councillors, and expressing an opinion about a decision of council. And I think what I heard was that it's allowable for a member to not agree with the decision and state that publicly, even though it is a decision of council. Is that, am I correct in that? In other words,
You can express your personal
right,
opposition, but you can't disparage those that supported it, or the bases on which they supported it.
but hypothetically, someone could say to any of us, ask a question about a decision of council, and the response could be, it's a decision of council. I don't necessarily agree with it, but it's a decision of council.
That's what you should be saying.
Yeah. Right, okay.
Yeah, I mean, I did find a breach of a code where a mayor actually said, that is absolutely disgusting, what they did. And it had to do with a resolution that was passed by a majority of council over that mayor's wishes. And I thought that was crossing the line to be saying, that's absolutely disgusting what they did. So anyway, but, you know, civil and respectful
Right.
disagreement is permissible.
Sure, okay. Kate?
Just to you more than to our integrity commissioner, I think it's really important to express dissent and reasons for dissent. And it's something that I think we've discussed in training sessions before, that we're responsible to a community and constituents, and they should hear from us about our rationale. I don't like if it gets manipulated to create sides, or to create or to foment anger. However, I think that dissent is a critical piece that we should be sharing with our community.
Okay, anybody else? I don't see any reason for us to go into, I think we covered everything.
Thank you very much for being so responsive.
I've got a lot more questions. I was sort of waiting for closed.
You want to move, you've got more questions? Like to, okay. Have you got time?
Yes.
Okay.
I should be out by 11:30, but I see we have more than half an hour.
Okay. So we need a, Phil? Want to move that?
I'm perfectly comfortable having questions asked and answered and open. I think the public would very much benefit from, I think the public would benefit from all of this conversation, unless it's something very specific to an individual, which I can understand, but.
Yeah, specific.
Okay.
That could be identified based on lines of questioning.
Okay, all right, then, thank you for that clarity.
I just want to add that if someone has a question about a specific issue related to themselves, that could be dealt with on a one-on-one basis by contacting me. And I wanted to add that any advice I give is confidential, unless it's misrepresented publicly, and then I would correct it. But the presumption is everything is confidential that's raised with me.
Concerning the confidentiality of integrity commissioners' reports to us individually? Okay, which would be, we don't need to, do we need to get consent from you to share opinions we've received from you or commentary that we've received from you, or can we liberally share that at will?
You can share it.
Thank you.
Sorry. Through to the mic. Just before, as the municipal clerk has vacated council chambers, can you just confirm, has the disclosure of pecuniary interest and general nature thereof happened? If not, can we do that before? Yeah, before we did it. We did do it already? Perfect. And then just the motion to move into close then.
Motion to move into close at 10:56 a.m. Oh, you want, sure, thank you. To consider educating or training members with the newly appointed integrity commissioner pursuant to section 239 in the Municipal Act.
Okay, we set?
Go ahead, bylaw, confirmatory bylaw?
Mover and seconder, please, for the confirmatory bylaw. I'll read it, that the following bylaw be read a first, second, and third time and finally passed. A bylaw to confirm the proceedings of the Council of the Corporation of the County of Prince Edward, a special meeting held on May 6th, moved by Councillor McNaughton, seconded by Councillor St. Jean. Those in favor? And that carries. And the motion to adjourn, Councillor Branderhorst, seconded by Councillor McNaughton.
Branderhorst,
favor?
not in motion that this meeting now adjourn at 11:31 p.m. AM.
Okay, in favor? That carries.
AM.